The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess, I'll sit.
Please be seated. Thank you, and I apologize that we were starting a little late. We did meet with the students over the break, and of course, I always talk too much, so. But they had some great questions for us. Glad to do that with. So, Mr. Shima, would you please call the 10:30 docket?
Thank you, Allison. Thank you. First case for the 10:30 a.m. docket for Wednesday, September 11th, 2024 is appeal number 125739, State of Kansas versus Clyde James Barnes Jr., Johnson County, briefs both sides.
May it please the court, Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant, Clyde Barnes, present and ready for argument.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas, present and ready for argument.
Second case is appeal number 126225, State of Kansas versus Patricio Gomez, Sedgwick County, briefs both sides.
Good morning. Emily Brandt of the Appellate Defender Office appears on behalf of Patricio Gomez, present and ready for argument. May I request 5 minutes for rebuttal this morning?
5 minutes is granted.
Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready.
Your Honor, that will conclude our 10:30 docket.
Thank you, Mr. Shima. We'll ask counsel in 125739, State of Kansas versus Barnes, to please come forward.
May it please the court, Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant, Clyde Barnes. Your Honor, may I please reserve 3 minutes of rebuttal argument?
Yes, 3 minutes is noted. Thank you, Mr. Shire.
Thank you, Your Honor. It's my intent today to briefly cover issues 1 and 5 of the briefs. Those issues relate to the premeditation instruction given in this case and the vicinage element of Clyde's tampering with electronic monitoring equipment conviction. I do want to respond to this court's specific concerns, so please do not hesitate to redirect my argument. Starting with issue 1, the issue here, at least in terms of error, is whether PIC's standard definition for premeditation is both legally accurate and provides sufficient guidance to jurors in their deliberation in a first-degree murder trial. I truly believe that it does not. And to make my case, I'd like to start by pointing out that premeditation has no statutory definition. It is a judicially defined term. Recently in this court's case law, I believe this court has done a good job of building up a positive definition for what premeditation is and what it entails. So as an attorney, I have a pretty good understanding of what premeditation means in the state of Kansas. The problem in this case and in so many other cases is that jurors are not lawyers and they do not read this court's opinions. So all that Clyde's jury had to figure out what premeditation meant in this case was standard PIC instruction. I think the problem with PIC is that it gives two positive definitions for what premeditation is. One of those positive definitions, I believe, is insufficient, and the other, I believe, is simply wrong. I'll start with the insufficient definition. PIC begins, premeditation means to have thought the matter over beforehand. To me, this is equivocal. I think some jurors could walk away from this instruction thinking that this just means intent before the act. Thought, intent, potato, potato, same thing. That in and of itself is problematic. But what makes PIC completely unacceptable as legal guidance, in my view, is its follow-up positive definition for what premeditation is. PIC goes on to say, quote, in other words, and in other words, to me, means different way of saying the same thing. In other words, to have formed the design or intent to kill before the act, period, nothing else added. PIC tells jurors that all premeditation means is intent formed before the act, and that is at odds with this court's case law. This court's recent case law has been very clear that premeditation includes a timing element and a cognitive element. To premeditate, somebody really has to deliberate on an initially formed intent. Do I really want to go through with this? PIC leads jurors to believe that all you need is intent before the act. Even a nanosecond of intent before an act would qualify as premeditation, in my view, under PIC. And that makes the definition hollow and meaningless because intent always precedes action. If intent does not occur before an act, it is involuntary. It's by definition is not intentional conduct. And so for that reason, I would implore this court to go one step further than it has in the past and recognize that a modification of PIC would not simply be best practice, that it would not simply bring more clarity. I am asking this court to find that PIC is simply erroneous. Turning to clear error, because the instruction was not objected to below, what we would have to show to demonstrate an entitlement to a new trial is to firmly convince this court of a real possibility of a different verdict, but for instructional error. And I think that we can show this in this case, and really in most cases, because of A, how hollow the definition of premeditation is that we're starting from using PIC. Under PIC, essentially any killing that is intentional is also going to be premeditated. And I think if this court, if a trial court defined premeditation in accord with this court's case law, it would be extremely difficult to prove because it is a thought process that is occurring entirely within a perpetrator's mind. It would have to be proven basically from inferences drawn from circumstantial evidence. It would make it very difficult to prove a case on that element beyond a reasonable doubt.
Why didn't that happen here, given the facts of this case?
Given the facts of this case,
If you got the instruction that you wanted, wouldn't the facts of this case suffice?
Suffice in terms of sufficiency of the evidence.
Premeditation? Wasn't there ample evidence of premeditation in this case?
To support a conviction were it challenged on sufficiency grounds, I believe that there would be. But the question of whether a jury would have inevitably made that finding, I don't believe so. There might have been evidence of planning to enter a residence, but there is no way of knowing with absolute certainty what was going through a perpetrator's mind in the moments before the actual killing acts.
But absolute certainty isn't required. It's beyond a reasonable doubt, correct?
Well, that's correct, Your Honor. And I would say a jury verdict would not have been guaranteed under that beyond a reasonable doubt standard either, which is an extremely high bar to clear in any criminal case. I believe that there is a real possibility of a different possible outcome. And for that reason, I would respectfully ask this court to reverse Clyde's conviction. Moving on to issue 5 of the brief, the issue here has to do with state constitutional vicinage. And Section 10 of the Kansas Constitution Bill of Rights explicitly requires a criminal charge to be brought in the county in which it was, quote, committed. This court's precedent gives a pretty definite definition of what it means for a crime to be committed within a particular jurisdiction. For a crime to be committed within a particular jurisdiction, a defendant must have therein committed an overt act, or the crime must have been completed. As I read the state's brief, I don't believe that there is disagreement on that interpretation of constitutional law.
In your brief, sir, you mentioned on page 35, and I'll quote, in 1859, when Section 10 was enacted, it was widely accepted at common law that a crime was committed in the jurisdiction where the overt act or the effect of the overt act occurred. And you cite to Addington. Do you agree with that? Do you agree that that is the explanation of our Constitution in Section 10?
Absolutely, Your Honor.
And it appears to me that you have approved of Addington's conclusion that to commit a crime in one location by virtue of an act's effect, it was appreciated that the effect needed to complete the crime. You mentioned that from Addington, correct?
That's also correct, Your Honor.
So, and then you cite the example that if, for example, someone is poisoned in, say, Missouri, but they pass away from the poisoning in Kansas, that Kansas has jurisdiction because the effect of the poisoning occurred in Kansas, correct?
Correct, Your Honor.
And that relates to you can't have a murder unless you have a deceased victim, right?
Correct.
So, how is that different from what we have here, where you have a person who tampers with an ankle bracelet in Missouri, but the immediate effect of that is to terminate supervision of Johnson County District Court in Kansas? How is that different?
Well, Your Honor, I think what is different is that in the homicide example cited in Addington, the crime simply did not occur when the act was committed. It consummated in Kansas after a passage of time. In the case at bar, Mr. Barnes was alleged to have tampered with equipment in Missouri. As soon as he tampered with that equipment in Missouri, the crime was finished and completed. So for that reason.
But can't you can touch, if it itches down there, you can touch it, you can tamper with the ankle bracelet. It's not a completed crime unless there is a defacing or disfigurement that has to do with the Johnson County supervision, correct?
I actually disagree on that point, Your Honor. I think looking at the precise statutory language of the tampering statute, the only overt act is removing, disabling, altering, tampering with, damaging, or destroying. It doesn't require that a supervising party no longer have the ability to continue supervision. As long as there is some tampering, even if that tampering is ineffective, I believe a prosecution would still be viable by the plain language of the criminal statute.
If we were to be persuaded by your argument, would the ultimate effect be that no one could ever be monitored out of state or out of jurisdiction?
No, Your Honor, I don't believe so. And I would say for two primary reasons. Number one, first of all, you could always revoke bond in the underlying criminal case in which supervision was ordered. There would be nothing that would prevent a district court from doing that. There may also be civil ramifications for tampering with electronic monitoring equipment out of state. And in addition, a individual would be subject to any criminal statutes within the jurisdiction in which the tampering occurred. Now, I don't know if Missouri has any criminal statutes that would cover this particular conduct, but if it did, then anybody who committed such acts in Missouri would be subject to prosecution in that state.
So how would they bring that? So you're saying Missouri would have jurisdiction to?
Presuming that they had a statute like Kansas's, yes. If you look at Kansas's statute, there's no requirement that that the monitoring be ordered by a Kansas court. The statute says that if you have electronic monitoring ordered by a court and the device is tampered with, it's a crime. So hypothetically, if we flip the factual scenario and an individual is ordered to submit to electronic monitoring equipment based on a Missouri court order, the electronic monitoring equipment was tampered with in Kansas, a Kansas prosecutor could bring charges in the state based on that act of tampering.
Okay, so, but and that is a great intellectual answer. But from a common sense point of view, wouldn't what you're arguing for pretty much, do you foresee that courts and court services would no longer allow people to be out of jurisdiction? I mean, are you making this argument have you thought about the effect of your argument on everyone?
Your Honor, I cannot pretend to assume that I know what the long-term ramifications of the arguments that we're advancing in this case would be. I'm basing my argument entirely on what I believe the Kansas Constitution, particularly Section 10, demands.
In Addington, the court found that the effect that was claimed, which was the empty elevator, was not really an effect of the false receipt. The completion of the crime, which they were focusing on in Addington, was that you have something that is false, and then you try to get a loan with that false statement. He said it really had no effect on the grain elevator. That wasn't really part of the criminality. But would you agree that in Addington, there was no effect on the grain elevator by what the defendant did in issuing the false receipt?
I suppose that's correct, but as I understand the state's arguments in this case and the prosecution's argument in Addington, the argument is that we have a condition within a particular county in Kansas that made an act outside of a county unlawful. And I think the takeaway from Addington, at least my takeaway, is that conditions that make extraterritorial acts unlawful do not confer district courts with jurisdiction over a charge.
What is the relationship between 215106B, which I'll call their territorial jurisdiction statute, and Section 10?
The relation...
Or is there one?
Well, I think it was intended to codify Section 10, but I don't believe that it was successful in doing so because I believe Section...
Well, it's not a venue statute. It's essentially arguing or sets the boundaries when the state of Kansas can assert territorial jurisdiction, so to speak, over an offense that occurs partly inside territorial boundaries and outside territorial boundaries, right? It doesn't necessarily direct us to which county would be the appropriate location if territorial jurisdiction exists. So I guess I'm just wondering, is that really what the statute is intended to do? It doesn't even matter. I mean, it seems to me that you could just argue that Section 10 was violated. We don't necessarily have to even reach that question, do we? About Section 10's impact on 215106.
I think that's potentially correct, Your Honor. If this court were to find that there was no jurisdiction under the Kansas Constitution, that would resolve the issue. To the extent I think that there may be a statute that allows that to happen, obviously constitutional law would trump statutory law.
But that, if I can just clarify, my understanding of that is that we wouldn't even need to get there. If we find that the Constitution allows the crime or an overt act and the effect of the overt act to allow jurisdiction in either state.
I think this does ultimately turn on this court's interpretation of constitutional law, Your Honor, correct. If this court believes that there is no constitutional vicinage, then the conviction cannot stand. If the court believes that there is constitutional vicinage, then the conviction would stand. And I far exceeded my time, Your Honor. I'm prepared to conclude my initial argument at this time.
Okay, thank you.
May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas. Jessica Smith was a 43-year-old single mother of two who had obtained a protection order against Clyde Barnes, prohibiting Clyde Barnes from coming to her residence. And early one July morning, when Ms. Smith was home, Clyde Barnes went to her house and killed her. It was a premeditated killing by essentially all measures. He started by removing the GPS ankle monitor from his ankle that was placed on him so that courts could supervise, could monitor his whereabouts and protect Jessica Smith's. And when he removed that ankle monitor from his ankle, he then retrieved a large gardening implement, a mattock, from his home, and he got in his car and he drove to Kansas. And he came to Jessica's house. He parked a distance away in his very distinctive car. He wore black from head to toe. He donned a mask in July in Kansas. And he went to Jessica Smith's home with the mattock, with rubber gloves on his hands. And he proceeded to enter the home. Mr. Barnes now advances an argument that premeditation is not foreseen here, that there's not sufficient evidence effectively of premeditation, because he argues while it appears apparent that the assailant may have contemplated what he deems a frightening encounter with Jessica, there was not overwhelming evidence that a killing was premeditated here, and the state disagrees with that contention. Every bit of evidence shows that this was premeditated. When Mr. Barnes entered into Ms. Smith's home, very little confrontation ensued. He just essentially immediately killed her with the mattock. He dealt several blows to her, including blows to her body after she had been felled to the floor, blows that were left in the linoleum floor in the kitchen. He killed her and then he fled the home and he stripped off the clothing that he wore. He fled in his car that became disabled on his way home. He dropped some of the rubber gloves. He was wearing rubber gloves that had her DNA on the outside and his on the inside. The mask was found in his car later that had her DNA on it. This is not a case with direct evidence of premeditation coming in the form of Clyde Barnes telling a police officer or telling the jury that I went there to kill Jessica Smith. But by every measure, that's exactly what he did. And a jury reasonably inferred as much. And the premeditation instruction that the court gave that was the pattern instruction that this court has blessed for decades, was adhered to by this jury. And it was more than sufficient for the jury to understand the concept of premeditation. And diverging just a bit from the nuance of this argument about premeditation and which words mean what, the state would like to point out that the more we as lawyers or as courts play with and extend or curtail or tweak these jury instructions, the net result of those actions is we take away power from a jury. What we have here in Kansas is a right for a defendant to have his case heard by a jury and decided by that jury. And every time we tweak it and narrow a jury's ability to decide the facts of a case, by curtailing instructions such as this one, the net result is all that we do is we remove power from a jury. We should be doing the opposite. We should be instilling a jury with the authority to decide the facts of the case.
But if the
Premeditation-
revision is consistent with the law and helpful to the jury in its deliberations, I don't see how that at all interferes with the role of the jury.
It may not interfere with it to the extent that instructions that would be helpful to them or guide them in their deliberations are justified. That's what this instruction did, though. And the more we sit here as attorneys and tweak that definition, word for word, pick apart every word, every or, every comma, and add more and more to it, all we do is curtail their ability to decide a case. This premeditation.
Sorry, I don't mean, can you give me your best argument why this was not, the pick instruction given was not misleading to the jury?
It was not misleading at all because within the words of this instruction, it adheres to exactly what this court has recommended, that a jury be instructed both on the temporal and the cognitive elements. And that's the argument that Mr. Barnes is advancing here. He's saying this instruction is insufficient to instill upon a jury the importance that they find both a cognitive element and a temporal one. But when you look at what this pattern instruction says, it covers both of those, including in the phrase that Mr. Barnes takes issue with. Premeditation means to have thought the matter over, cognitive, beforehand, temporal. In other words, to have formed the design, cognitive, before the act, temporal. And so by every measure, every sentence of this pattern instruction covers the cognitive and the temporal elements. And if this instruction is going to mean anything, which this court has made clear for decades, there's not a fixed amount of time. The state need not prove that the defendant thought about it for an hour beforehand and designed the plan and had time to reflect on it and time to back out and all that. This court has said time and again, it need not be a day or an hour or a week or a minute, but there needs to be something there that this was not an impulsive act without a design to kill. Furthermore, so, and it's recent cases from this court has picked apart this pattern instruction over and over in very recent cases and has made clear that a better practice may be to add some verbiage to it. I don't doubt that the PIC committee will review those opinions. And as they do so often, perhaps they will revise the pattern instruction. But pattern instructions are not mandatory. A district court can diverge from those, and there's nothing magical about the pattern instruction. But this pattern instruction itself has been picked apart so many times and has been affirmed so many times that this trial court reasonably relied on this pattern instruction. And this court cannot be firmly convinced that this jury would have come up with a different verdict had they been given the verbiage that Mr. Barnes now advances, particularly in the face of absolutely overwhelming evidence of premeditation in this case. This case has every bit of evidence of premeditation short of a confession. So the state argues this pattern instruction was more than sufficient. It covered all the bases that Barnes urges a trial court to cover, and it should not be found insufficient. It should not be played with. Yet again, it doesn't need to be.
If I could redirect you before you get too far down on your time, could you give me your best argument that Kansas has subject matter jurisdiction here?
I could. When Mr. Barnes was up here arguing, I believe Your Honor pointed Mr. Barnes to a phrase on page 35 of his brief, which had been the same portion of his brief that I had highlighted before my argument today, which was that Mr. Barnes states that in 1859, when Section 10 was enacted, it was widely accepted at common law that a crime was committed in the jurisdiction where the overt act or the effect of the overt act occurred. And here the state advanced in its brief and advances today that the effect of the overt act of removing that bracelet was here in Kansas. And Mr. Barnes argues that he could distinguish this case from a poisoning that occurs elsewhere and then the death occurs here in Kansas because both of those are elements of the murder. And so the death happening here bestowed jurisdiction. And I would argue subject matter jurisdiction is proper here in Kansas because the effect of Mr. Barnes' overt act when he got the bracelet off, the ankle monitor off of his ankle. The effect was it made it a Kansas court unable to continue to supervise or monitor Mr. Barnes' whereabouts. The sole purpose of putting that ankle monitor on him was to be able to monitor his whereabouts. So when we look at the effect of the overt act, while the effect is not an element of this offense, it's not an element of tampering that the tampering must be to an extent that it inhibits or makes impossible a Kansas court from supervising him. That's not an element. That's true, what Mr. Barnes says. But nevertheless, the effect of the overt act did occur in Kansas. It need not be an element of the offense to still be an effect of the offense or of the overt act. And this court doesn't need to go far in seeing that this is the net effect of removing the ankle monitor, because even though the words are not in the statute about monitoring, that the monitoring could be cut off, there's simply no other reason for a legislature to enact this legislation. We don't need to look beyond the legislation itself to understand why would it be a crime to cut off an ankle monitor. It wouldn't be a crime because for any other reason other than that it inhibits a court's ability to continue their monitoring supervision of the defendant. And so that's the obvious effect of his tampering with this bracelet.
Can I ask
And that
you-
effect was held here.
Go ahead.
I was just going to ask you a question about the nature of this right under Section 10. We haven't had a lot of cases, or opportunity, at least since I've been on the bench, to evaluate this provision. So it went back, it's interesting, some of our earlier cases like State v. Potter and State v. Kending, late 1876 decisions that describe this right as a personal privilege that may be insisted upon or waived by the person that possesses that right. And the rationale is pretty obvious that a defendant shouldn't be allowed to sort of game the system by sitting on the right to insist upon a different venue location and test to see whether or not they will get an acquittal. And if unsuccessful, then assert the right and say, Allah, we've got a problem here. And I think that's the rationale in those cases, but is this a waivable right? Must it be asserted at or be waived by the defendant at trial?
It's an interesting point you raise because I make a version of that same argument within the prosecutorial error claim within this brief, is that it should have to be raised. But this court would be justified in finding as much, that it is a waivable provision that Mr. Barnes never asserted until he arrived here.
But done. I hate to interrupt you, but I want you to add done into your answer. I mean, I've got the same problem that you're talking about here, but I want to add done to the mix, because done tells us when subject matter jurisdiction attaches, and that's to the properly charging documents. This is, a venue provision. And so doesn't that help answer the question?
It does, I believe. It conflicts somewhat with the line of cases and with the preservation argument that Mr. Barnes makes, which is that jurisdiction is a question of law that can be raised at any time and is reviewed de novo. But I understand that Dunn likewise says there are provisions within the complaint and notice provisions within a complaint. Those are waivable as long as a defendant understands the charges against him and what he's being charged with and so on.
Going back to your interpretation or construction argument, much of what you talk about in terms of what was understood at the time of the adoption and just in legislative intent as to this tampering statute are not based upon our rubric of starting with the plain language. And only if we can't discern meaning from the plain language do we move to those types of tools. So if we look here at committed, is the plain language of committed the actual act of tampering only? And how do we make committed so broad that it incorporates the Johnson County court order?
I believe it encompasses the Johnson County court order because absent that court order, the crime wouldn't be committed. By that, I mean, if the Johnson County court order, for instance, if the Johnson County court order expired on its face, but he still had the ankle monitor on, if he were to cut it off in Missouri, we would have no crime. If he were to cut it off in Kansas, we would have no crime, other than perhaps a criminal damage or something for court services property. But we would have no crime. It wouldn't have been committed. It wouldn't have been completed because there would be no supervision. So that's a necessary element to the offense. And if that is not present, then no crime has been committed. It's not that long ago that it wasn't a crime to do this. When GPS ankle monitors first became part of supervision, there was no crime on the books for tampering with this. And so if one cut it off, they might have their bond revoked, or they might have their probation revoked, and they might be hailed back into court for that. But there was not this separate crime provision. So that's what bestows jurisdiction. With what time I have remaining, I would like to briefly point this court to the state's argument that it should reconsider the preservation angle that this court has taken on closing argument error. And the reason it should reconsider it is because defendants should be required to contemporaneously preserve arguments that a prosecutor has committed error in closing argument, and give a trial court an opportunity to correct it. Give a trial court an opportunity to get it right. That's exactly what this court requires when it comes to evidentiary errors on appeal, is that there be a contemporaneous objection. There's no reason not to have the same.
Is that by statute?
It is by statute.
But there's no statute regarding non-evidentiary.
There is not. And if this court continues to allow those without contemporaneous preservation, then perhaps the resolution of it is a legislative.
And I think part of the reasoning behind not requiring a contemporaneous objection in closing or opening is that the disruption factor. I mean, that's one of the considerations I think we've given, is that if a prosecutor is constantly engaging in proper argument, or speculatively by defense counsel's point of view, it's a constant interruption in the flow, and that in itself can disrupt the trial. I think that's part of the rationale why we don't require it. How do you respond to that?
But if a prosecutor is engaging in that conduct, they should be interrupted. If there is a basis for the objection, a viable basis that should be argued, then they should get interrupted, and a trial court should have an opportunity to correct that and clarify it for the jury, for judicial economy, for all the reasons that we require as much in the evidentiary context. Those justifications are even more paramount in a closing argument. Sure, we don't want to interrupt the flow, but that's a concern for a prosecutor. Then they need to both get their closing argument correct and within the confines of the law. And if their flow gets interrupted by objections, then they need to be able to work past that, just as we all work past questions from this bench when we're up here at oral argument. That's not a basis to forego preservation, contemporaneous preservation, and allowing in a murder case, when a jury is sitting and going through what I would agree is within the gruesome photos context, the traumatic experience of deciding a case such as this one, rather than toss out a verdict for a one-off we know in a closing argument, this court should at least require that the defendant preserved as much and gave a district court an opportunity to correct the error, correct the trial, correct the prosecutor, instruct the jury as necessary to disregard or whatever it might be, and get things back on track so that a jury understands.
There is another aspect to that, just besides the interruption. And I suspect you find our interruptions annoying. You need not confirm or deny that, but that is the concern I think defense counsel has of becoming an annoyance to the jury. Like, why don't they just let us hear what the prosecutor has to say? Because of course the jury wants to hear everything, right? They get annoyed with evidentiary objections as well. And so there is some tension with that perhaps as well. Should that be a consideration?
It shouldn't be a consideration when we're trying to get it right. We're trying to get it right. And the jury is already instructed both that arguments are not evidence, and that if anything is argued that is contrary to the evidence, it can be disregarded. But the jury's also instructed that objections may have been raised and ruled upon by the court, and that the jury is not to concern themselves with the basis of those. They're just to concern themselves with the rulings of the court. And so I don't believe as though this desire for defense counsel to not interrupt the flow of a prosecutor is as noble as it's argued. I don't believe it's a necessary justification to forego the contemporaneous objection requirement when the contemporaneous objection requirement that is required for evidentiary claims. This court has said time and again, and as noted, it's by statute. The state, if they improperly admit a piece of evidence against a defendant and convict that defendant, if he or she failed to object to that evidence coming in, they're out of luck on appeal and the conviction stands. And I would argue the risk to a defendant, the threat to a defendant by improperly admitted evidence is much greater, by leaps and bounds, exponentially greater than the risk that the state misstates something in a closing argument and that the jury hears that. The jury's instructed they can essentially disregard the argument, that it's not evidence. If it's contrary to the evidence, disregard it. And so to not require a contemporaneous objection on argument just conflicts so badly with the contemporaneous objection rule as it pertains to evidence that it's not justifiable. And these types of cases, a murder case from 5 or 6 years ago, when we're talking, whether it's Willis, whether it's Barnes, we're talking about egregious crimes that happened many times years and years ago.
Counsel, I know you're out of time also. I'll interrupt and dig in a little bit on your argument about closing. If we think about incentives, doesn't the way the law currently exists make sense out of, I mean, if we want to incentivize the parties to contest evidence, to have a contested process, adversarial system. We don't really want that in closing arguments. Do we really want to incentivize the state, for example, to push the boundaries? I mean, because that's what will happen. The state will be like, well, they have to object. I'm gonna try to get everything. And just the way that evidence is contested. And it seems to me that creates sort of a perverse incentive system for closing arguments.
I can understand the concern, but at the same time, if the concern exists that attorneys don't want to be interrupted, then the prosecutor should still have the incentive to play within the bounds.
Do you think that? Do you think that's what would happen?
I think generally they would. I don't believe requiring a contemporaneous objection would give license to prosecutors to start running rampant over the rules.
Well, no, I mean, but we all know how trials work, and there's no incentive to govern oneself when there's an external governing structure on top of one. I mean, on top. So.
And there still would be here, and there still would be when they object. And if a prosecutor is making argument that continually gets objected to because they've run roughshod over the rules, because they want to require an objection, a judge is going to keep telling a jury, disregard what the prosecutor just said. And it's going to eviscerate the credibility of the prosecutor in front of the jury. A prosecutor would have no incentive to be trying to provoke an objection from defense counsel that a court would then sustain with an instruction to a jury to disregard what the prosecutor just said, much less the jury just start to disregard everything the prosecutor offered the jury. Recognizing I'm out of time, if there's any further questions, I stand for them. Absent that, I would ask that this court affirm Mr. Barnes' convictions and sentence. Thank you.
Thank you. Mr. Sharp?
May it please the court. There are 2 points that I'd like to make on rebuttal. The first is that I don't believe that my colleague used the precise language used by Pick to explain how the instruction gets to the point of cognition in terms of what's required by premeditation. So the exact words of the in other words clause of Pick is, in other words, to have formed the design or intent to kill before the act. So even if the word design did in fact refer to cognition, thinking over, the or sort of obliterates that as something that's required for a jury to make a premeditation finding. All that Pick requires for a jury to return a guilty verdict on a finding of premeditation is an intent to kill before the act. And so for that reason, if nothing else, that language must be struck from PIC for this to be a correct articulation of the law. The second point that I wanted to get to was waiver in terms of constitutional vicinage. Is this a waivable constitutional right? Yes, I believe it is. That's what happens when a defendant requests a change of venue. This can be waived, but like all jury trial rights, the waiver has to be knowing and voluntary. So before the Section 10 right to a jury trial can be waived, a defendant has to be made aware that he or she has the right. And in this case, there was no intelligent or knowing voluntary waiver.
If it's a waivable right, it cannot be about jurisdiction, right?
Your Honor, I believe that Addington holds otherwise. Addington views this as a jurisdictional issue. And to the extent that we're dealing with territorial jurisdiction, it's not as if this prosecution, in my view, could have been brought in any other county in Kansas. It's simply a crime that no court in Kansas would have the authority to adjudicate, or a charge that no court would have the authority to adjudicate. And so I don't believe that that would be waivable.
Well, let me push back on that a little bit. Venue can be changed simply for an inconvenient forum, can't it?
Venue is referred to as in forum, but sometimes in its resolutions of criminal cases, venue is described as being jurisdictional because of Section 10. And in this case, because there is venue in literally no county in Kansas, I believe that it would have to be construed to be as jurisdictional.
But I guess I see it as more maybe akin to a personal jurisdiction, or, it's jurisdictional, but it has to be asserted or waived because it's that personal right. So I guess we don't require a knowing and voluntary waiver of personal jurisdiction. You know what I mean? With these sort of personal rights. But I guess that when you're coupling it with it to the jury trial aspect, maybe. Can you dig into that a little bit more? Do you know where I'm?
I believe I think I understand the court's concern. And what I would respond to is that this is an unusual sort of jurisdiction in that it's created through a constitutional right. So the constitutional right has to be waived. If the constitutional right isn't waived, there's no jurisdiction. That would be the best answer that I could give to this court in response.
Isn't this just, help me with this, why isn't this just very simple? Why isn't any tampering with a device that is monitored in Kansas, regardless of where it happens, an overt act in Kansas? Why isn't that? I mean, the entire intent is to monitor the behavior and it's monitored in Kansas. Why isn't it that simple? If I take off or destroy the ability of the Kansas court to monitor, why isn't that, regardless of where it happens, an overt act in Kansas?
It isn't an overt act because of the precise statutory language which prescribes tampering. The tampering is what happens to the device itself. The crime does not criminalize preventing a Kansas judicial officer from being able to monitor. The crime is tampering, and everyone, as I understand the briefing in this case, agrees that the specific act of tampering happened in Missouri. Unless this court has any further questions, I will.
Isn't it also possible to look at this as two acts? One act was the tampering or the fiddling with the ankle bracelet. The other was the act of terminating supervision in Kansas.
I don't believe so, Your Honor, because of the wording of the statute. The only act that a defendant has to commit to be guilty of this crime is the tampering. The severing of the court's ability to supervise is not something that's criminalized by statute. And to the extent we're talking about just there would be no crime unless a defendant had been ordered by a Kansas court to be subject to supervision, I view that as a condition that makes an act unlawful, which again, I believe Addington is very clear does not confer.
Aren't these systems two-way streets essentially? In other words, isn't there electronic devices that exist in Kansas that communicate with the bracelet? I mean,
Yes, Your Honor.
there has to be, right?
Yes.
And why didn't he, quote, disable electronic monitoring equipment used pursuant to a court order? That equipment specifically being the other side of the the other soup can.
Mm-hmm. I don't think that was disabled. The only device that was disabled, that the devices in Kansas were able to continue reading data from the device in Missouri. The data that they received indicated, at least in the view of the court operators, that the device had been removed from an ankle. So I don't think that any device in Kansas was disabled or tampered with or adversely affected in terms of how it functioned. It functioned perfectly well in Kansas.
Because the case was prosecuted as a removal.
Pardon, I didn't.
As a removal. In other words, he didn't smash the bracelet with a rock. He just took it off.
That's correct.
But first he had to disable it, didn't he? Didn't he first have to disable it by cutting it, taking it off?
Well, that didn't prevent it from transmitting data. I would view the prosecution as being predicated on an act of tampering, which is removing.
But there was evidence that there was in fact no monitoring during that 5-hour period.
I believe that there was monitoring. The communication, the devices continued to communicate with each other. And the data that Kansas devices received indicated that the device in Missouri had been opened and closed, essentially.
I thought
But when it did open it, I thought the facts showed that when he did open it, it stopped communicating for a period of minutes before he put it back on maybe I have the facts wrong.
Well, perhaps there could have been greater specificity in terms of how that was communicated at trial. I'm not sure that this was an issue on anyone's radar during trial. My recollection of the testimony is that there was a tamper alert, and I'm not exactly sure what that would translate to. Unless this court has any further questions, I'm prepared to conclude argument at this time.
I see none. Thank you.
Thank you, Your Honors.
Thank you to both counsel for your arguments in this matter. The court will take it under advisement. We now turn to 126225, State of Kansas versus Gomez. Counsel.
May it please the court, Emily Brandt on behalf of Patricio Gomez. I plan to focus my remarks today just on issue 1, the sufficiency of the evidence supporting the alternative means charged by the state to support a felony murder conviction. Patricio is ultimately asking this court to vacate his conviction for felony murder. I'll start with the attempted distribution of methamphetamine as an alternative means to commit felony murder here. The state was required to prove that Patricio killed Martinez during the attempted distribution of methamphetamine. It's Patricio's contention today that he completed the crime of distribution. Patricio went to the hotel room that day to sell methamphetamine. Methamphetamine was weighed out. Methamphetamine was found in the hotel room. KBI lab analysts testified that it was in fact methamphetamine. There was testimony that the decedent Martinez was trying to find a container to put the methamphetamine in. And today we're asking the court to reject the state's argument that the statutory definition of distribute is irrelevant, as it merely describes the factual circumstances under which the material element of distribution may be proven. Here, distribute is defined as in the statute and was provided in the jury instructions that distribute means the actual constructive or attempted transfer of an item from one person to another. If an attempted transfer of an item from one person to another is a factual scenario in which distribution can be completed, and that factual scenario is present here, Patricio was trying to transfer this methamphetamine to the decedent Martinez, then we have sufficient evidence that he actually completed the crime of distribution of methamphetamine. The state has relied on State v. Castleberry, 301 Can 170, to argue that that the state didn't need to prove this factual scenario, this attempt to transfer in order to prove that an attempted distribution of methamphetamine occurred. Patricio would agree with that. Castleberry, we're looking at something totally different here. This was a challenge to the jury instructions. Castleberry had conceded that there was sufficient evidence of both actual and constructive transfer of methamphetamine, but was trying to argue that the actual, constructive, and attempted transfer of methamphetamine all created alternative means by which to commit the crime of distribution of meth. So there needed to be sufficient evidence of all three of those means in order to convict him of distribution of methamphetamine. Patricio's not making that argument. He's not arguing that those three factual scenarios are alternative means. He's arguing that one of those factual scenarios, an attempt to transfer methamphetamine, occurred here. And because that factual scenario was present, there's sufficient evidence to prove that Patricio Gomez committed the completed crime of distribution of methamphetamine.
Is it fair to say that your argument is that attempted distribution is an impossible crime in Kansas?
I think that that would be an accurate depiction of my argument, Your Honor, because we have chosen to define distribute to include an attempt to transfer. If you attempt to transfer, you've completed the material element of distribution. And it was the state's choice to charge this as an attempted distribution of methamphetamine, and it's our contention that they failed to do that. We would next ask the court to reject the state's argument that attempt to commit here has some unique meaning in felony murder land, as applied here to Patricio Gomez. Even if we accept the premise that attempt to commit does have a special meaning within felony murder land, here the state didn't choose to instruct upon or charge upon distribution of methamphetamine. And that during the res gesta of trying to complete that crime, the decedent Martinez was killed. They chose to charge attempted distribution of methamphetamine. I don't know if that puts us into sort of an attempt land, where you are saying that it happened both in the attempt to commit attempted distribution of methamphetamine. But certainly we would argue that claiming res gesta doesn't get us out of the problem that we have a completed distribution of methamphetamine. And the state chose to charge as the inherently underlying dangerous felony attempted distribution of methamphetamine. Moving to the attempted aggravated robbery, I would simply ask this court that the record bears no support for this means. This was a drug transaction that ended incredibly tragically. But Patricio wanted to sell methamphetamine. He was there to sell methamphetamine. All of the testimony supports that during this transaction, the decedent Martinez ended up dead over the inability to pay via an electronic payment. So, and I think that the jury saw this. They acquitted him of the attempted aggravated robbery. So we would ask this court to find that there's insufficient evidence of both underlying means here. And because there's insufficient evidence of both underlying means, we can't have a felony murder conviction. And so that conviction needs to be vacated. In the alternative, I will just mention as a final point that If this court finds sufficient evidence of one of the means, Patricio is respectfully asking that this court not follow the new rule of law pronounced in Reynolds, because one, it is a new rule of law. And two, it creates a substantial hardship and prejudice to Patricio because at the time he was tried, there was no burden on him to preserve an alternative means argument for this court's review by objecting to the instructions, since it was just a sufficiency standard at the time of his trial. So we'd ask that if this court gets into alternative means land, that they still reverse for a new trial on the means.
I guess the difference I've got with you on this one, setting aside even the alternative means stuff, the whole purpose of this alternative means error theory is the confusion of the jury as to which, and not being able to tell once you get a conviction what it's based on. And it might be based on something where there's insufficient evidence. But we have a jury verdict form in this case, and the jury specifically found him not guilty of attempt to commit an aggravated robbery. There's no confusion what the jury found. So what's the point?
Well, respectfully, Your Honor, this court has a long line of cases where it has held that inconsistent verdicts in felony murder land are perfectly fine.
How is this inconsistent? Okay, it got pled. The jury came back, looked at the evidence, and said no attempting to commit aggravated robbery. There's no confusion, right? We know what the jury found. They found him guilty of attempting to distribute. You can argue the sufficiency of that all day. That's fine. I get that. I don't see why you get to use the alternative means theory when you have a specific verdict form that tells us what the jury found. You see what the point I'm making?
I understand your point, Your Honor, but again, this court has previously held that a jury can both acquit of the alternative means, and there can be sufficient evidence of that means to support the felony murder conviction. So I guess in my view, again, my argument today is that there is insufficient evidence of both of the means, but that if you find sufficient evidence of both means, that then we don't know which one the jury relied on to support the felony murder conviction. I mean, we know that they found him not guilty of the attempted aggravated robbery on its own, but this court has held that every single charge in an indictment or an information or a complaint, they are separate and distinct from one another. So we know that they didn't find him guilty of attempted aggravated robbery as a standalone offense, but we don't actually know what the jury decided when they went back there as to the felony murder.
Do we even need to get to alternative means? Because it seems to me that if you lose your sufficiency challenges, you lose the alternative means argument because there's sufficient evidence of both theories. But if there's insufficient evidence, there's insufficient evidence. So isn't it all turn on the sufficiency of the evidence at
Yes,
the end of the day?
yeah, alternative means was always my alternative argument.
Okay.
So yeah, if you find that there's insufficient evidence of both means, Patricio and I would greatly appreciate if you didn't get to the alternative means argument. But if you find there is sufficient evidence of both means, then I think we still have an alternative means problem because, or if you find that there's insufficient evidence of one of the means, but sufficient evidence of the other means, then we have an alternative means problem. And again, that would be under State v. Wright and not the new law under State v. Reynolds, in which neither of us have.
That's not necessarily true, though. If the jury find, well, you haven't proved beyond a reasonable doubt all of the elements of aggravated robbery because we don't believe certain things and we believe other things. That's different than a sufficiency examination. So you can have both, right?
Yes, you can have both. You can have both, Your Honor. I'm sorry if I misspoke. You can certainly have, again, this court has held that it's fine to have inconsistent verdicts in felony murder land. It is fine for the jury to acquit on the standalone charge of attempted aggravated robbery, but also fine for there to be sufficient evidence of that means to support felony murder. And so it is okay for those verdicts to be inconsistent. So my argument today is that, one, there's insufficient evidence of either means, so the entire conviction of felony murder has to be vacated and he can't be retried. But in the alternative, if this court finds that there's sufficient evidence of at least one of the means, but insufficient evidence of the other means, then we have an alternative means problem because they need sufficient evidence of both means.
Okay, so let me ask you a question. If there's, let's say hypothetically, we find sufficient evidence of both means. I want to be able to understand your argument about Reynolds and Wright. Are you saying that, that because your client, when it goes to reversibility, you know, viewed in the light most favorable to the state, the evidence shows beyond a reasonable doubt. You're saying that it has to go back because he didn't know that he should object. Is that? Because now we're looking at sufficiency of the evidence under
Yes.
Reynolds.
Yes.
If we do the Reynolds, you know, well, I know, let's pretend.
Well, under Reynolds, we'd be doing instructional error.
Okay, right. So I guess I'll break it down a little bit further. If it's instructional error, you look at whether it was legally sufficient.
Right.
And your position is it wasn't factually, right?
Right, yeah.
Okay.
Yes.
So let's say that we're not convinced by that and that it's factually sufficient on both means. Then you go to reversibility and your client didn't object.
Correct. So we'd go to clear error.
So it would go to clear error and you know, so are you conceding that you would just lose on that or what if that, take me down that road?
Well, I haven't briefed it. So if this court is interested in us briefing the Reynolds issue, I would appreciate an opportunity to supplementally brief that. But I mean, I think in this world of felony murder, if you find that both of these means were factually sufficient, I'm not sure standing here without supplemental briefing how we could see that they are legally insufficient, since the felony murder statute clearly delineates that both distribution of methamphetamine and aggravated robbery are inherently dangerous felonies that can be charged to support a felony murder conviction.
So it's legal, so you would say it's legally appropriate, right? Or not?
Tentatively, without briefing it, I think that I would,
Right.
that's where I think it would lead us to. But Patricio was never, he was never given the opportunity to object in this way because he didn't know that he had this burden to object. Because prior to Reynolds, he could get the super sufficiency alternative means standard, which doesn't require any objection for preservation purposes.
But you would still lose under that framework if there's sufficient evidence supporting both inherently dangerous felonies.
That's correct. Under Wright, if there's sufficient evidence of both alternative means, then Patricio loses. So our primary argument, again, is that there's insufficient evidence of both means because we have a completed distribution of methamphetamine and no evidence of attempted aggravated robbery. So, yeah. Unless this court has any other questions, I will save the remainder of my time for rebuttal. Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. The defendant reached out to his friend Shay Roberts to see if anyone needed work, a code word for methamphetamine. They got together, and shortly thereafter, it just so happened that Michael Martinez sent a text message to who he thought was also his friend, Miss Roberts, and seeking work methamphetamine. He wanted specifically 1.75 grams. The group of defendant and Roberts head over to the hotel to meet Martinez and his girlfriend. Girlfriend, Miss Hampton, lets them inside. They go upstairs. Roberts starts weighing out the methamphetamine. Defendant confirmed that it wasn't too much or too little, and then everything else went back into the purse. At that point, the victim in this case, Mr. Martinez, struggled to pay. He couldn't get Cash App to work. He started looking for a container while the defendant's friend Roberts, their mutual friend Roberts, used a printer. Ultimately, Hampton comes out. She tries to get Cash App to work. Doesn't work. The methamphetamine remains on the scale at that point. And I think that's the thrust of the state's argument as far as the sufficiency of the evidence, is that there's actually no evidence in this case of an attempted transfer of methamphetamine. There is evidence of an attempted distribution. And I'll get to that. As the Cash App program continues to fail, the defendant eventually pulls a handgun, and things get weird pretty fast based on the history of these individuals. There are accusations of extortion for clothing, accusations of extortion for personal identification information for identity theft purposes. There's a demand for profiles, demands for clothing. As Ms. Martinez began to comply, there's usage of a phone. The defendant takes the phone away from Ms. Hampton and throws it on the table. Ultimately, there's also argument about gang affiliation. The defendant even took a picture of his victim, Ms. Martinez, and the young woman, Ms. Hampton, that was there with him, tried to send it to someone, and ultimately, the defendant turns to Ms. Hampton and says, "I'm sorry, you're just at the wrong place at the wrong time." Again, while he has the gun out, pointing the gun. And at that point, the victim, Mr. Martinez, rushed the defendant, and they struggled until the defendant fired 3 times, striking Mr. Martinez once. Mr. Martinez continued to struggle. Then he realized he was shot. He ran and hid in the closet. The defendant and Ms. Roberts then flee. Victim, Mr. Martinez, comes out, slams the door, and there is a 911 call. He wasn't the only 911 call. Didn't come from that room. There were other hotel guests. Hotel staff got up there. They got Ms. Hampton out. Left behind were 6 methamphetamine crystals weighing approximately 1 gram. They were mostly on a nightstand between the bed and a closet, and there was 1 methamphetamine crystal on an ironing board. So what we have in this case, the state maintains, is that there was sufficient evidence of both alternative means of felony murder. And to be clear, the alternative means of felony murder were distribution of methamphetamine and aggravated robbery. What we had here
They were attempted, right?
Attempted.
Attempted for both of those, right?
You said evidence
Yeah.
distribution.
Right, excuse me, yeah. We alleged the attempted distribution of methamphetamine. And so what we ended up ultimately having is that the state believes that there was sufficient evidence of an attempted distribution, but there was no evidence of an attempted transfer. And that is a subtle but very critical distinction, because what defendant seizes on in this case in attempting to found his argument is what is a description of factual scenarios used as examples to try to highlight and define the word distribute. Not all of those have to be present in any single case. In fact, only one needs to be. There may even be something else that reasonable jurors could agree, or that would be evidence of distribution. And that's the key. Attempted distribution isn't an impossible crime, because the key here is transfer. And it is indeed possible, as this case evidences, to attempt to distribute methamphetamine without ever actually trying to transfer it from one person to another. In fact, all of the evidence here indicates quite clearly that the defendant had no intention of transferring any methamphetamine until payment came through, and that was going to come through either via cash, or ultimately, as things devolved over time, it was going to rob them. I think the Castleberry case is a critical one here, for a couple of reasons. Again, it highlights the fact that about the alternative means. We would just ask that that this court follow the state's analysis of Castleberry and its usage here and then move forward on to the sufficiency of the evidence. And ultimately what it comes down to is, again, is a situation where we have a defendant that wants this court to reweigh the evidence. The jury weighed this evidence. As Justice Biles pointed out, they clearly weighed the evidence. They didn't convict of everything. Now, that may be the only point that I would agree with opposing counsel today, is that I don't know that that means we're in a full-on Reynolds situation. Because in felony murder, you can have inconsistent verdicts. It is possible here that there were 11 jurors that felt that both were present, and one juror felt that there wasn't sufficient evidence of an attempted aggravated robbery. But ultimately, that doesn't matter for felony murder purposes.
Before you get fully into super sufficiency, sort of right,
Sure.
Reynolds land, and I'm sorry to make you do this. I'm struggling with this notion that attempted distribution is an impossible crime. And I want you to walk me through it. I know you just covered it, but
It's all right.
you said it's not an impossible crime. And of course, I understand that is the state's position since that's what was charged, but
Sure.
help me understand that. And I do have the language in front of me.
And that's what if you give me just a moment, I'm going to try to get to that language here.
And as you're looking, my sort of underlying question or follow-up would be, are there any appellate cases, Court of Appeals or from our court, that talk about this question, this statutory anomaly of having the word attempt in the actual crime itself?
I think the closest that we probably come is Castleberry, and the fact that it's very clear that what these things are not elements. They're factual scenarios that can help illustrate what it means to distribute something. And the definition of distribute, and it was given here, is the actual constructive or attempted transfer from one person to another of some item, whether or not there is an agency relationship. And then it goes on to include that distribute includes, but is not limited to, the sale, offer for sale, or any act that causes some item to be transferred from one person to another.
And you're reading from the statute.
Exactly.
Correct? And then that language is essentially word for word repeated in the instruction.
Correct. And I guess the only other thing that I would note on that is that there,
but if that's a definition, I mean, we're talking about transfer,
Mhm.
and it says attempted transfer is distribution.
correct. The attempt to transfer is
Is there any other way to distribute other than transfer?
yes, the actual or constructive
But that's still transfer.
that would be a transfer. That, I think that's where that's the nub
But
that I'm trying to get at.
But they're all like this, the definition makes them all interchangeable and completely identical.
They are not identical. They are
Well, they're not
equivalent.
factually identical, but legally they're equivalent.
They are legally.
So an attempted transfer is legally equivalent to an actual transfer.
They are legally equivalent descriptions of facts that could support a distribution. Is the best way I can answer your question based on this case.
Is what you're saying that in fact, the exact same facts would support a conviction for both attempted distribution and distribution itself? I mean,
I don't think
your
so.
opposing counsel's argument is predicated on the idea that a defendant cannot be convicted on the same facts of both an attempt and a completed crime.
Right, and I don't think.
You agree with that?
I don't think that they could be convicted of both either.
Okay.
I think that what we're talking about here, again, the element itself, and I do wish it was a little more clear, but based on this court's case law, the element is transfer. And then we're tasked with the question of, well, what kind of things can the jury look at to evidence that a distribution has occurred? Well, you can consider the actual transfer, or if something's given over, then it has been distributed. constructive transfer. I think I have at least one example of that in my brief, and we get close to that here in that the defendant gave the drugs to somebody else to potentially give to yet a third party. And then you have an attempted transfer, which would be the actual act of trying to hand over the drugs. And that's the missing evidence here. There's no evidence that the defendant or his co-conspirator ever tried to deliver the methamphetamine by handing it over to another person. The closest it came was that the victim looked for a container
So
because he never did get it.
is it correct to say then that the crime of attempted distribution is effectively an attempt to transfer?
That one,
That sounds like what you're saying.
that one I think would be resolved because in my mind, that would be a factual impossibility.
Okay.
And I think that's how we resolve it ultimately, is that these are fact patterns and that scenario is a factual impossibility.
Okay.
Ultimately, the state believes that there was a super sufficiency of the evidence demonstrated in the instant case because this was a meeting to distribute drugs, but there was never any actual attempted transfer. What we had here was an attempted actual or attempted constructive sale that just never was completed because things fell apart and the defendant got upset and he killed someone because of it. We would also ask that this court upholds on the super sufficiency basis of the attempted aggravated robbery, because in his fury, the defendant clearly started demanding things and the victim in this case actually even started to comply. Ultimately, the victim or the defendant and his co-conspirator, there's no evidence that they actually got away with anything. In fact, they left a shoe behind. They fled so quickly. They left their meth behind, or at least most of it, as they fled so quickly. And so ultimately we believe that the super sufficiency of the evidence was satisfied in the instant case. If there were any interest in additional briefing following Reynolds, again, based on the super sufficiency, we don't believe it's necessary. And would ask the court to uphold as it is currently briefed. Very, very briefly, in my issue B, like 1B, I discussed that attempt has to mean something a little bit different in the felony murder context. I think that's pretty plain on its face, because an attempt to be convicted of an attempt crime, you have to have failed to complete the crime. In felony murder, a killing can occur during an attempt, and that's the point of the res gesta element. And my argument in that regard is that simple. And I think that's what all of the cases that I cite in that section emphasize. I also think that that's what we have here is very similar factual scenarios to those cases. If there are no other questions, the state is aware that there is one sentencing error that has to be addressed here, but we would ask that the defendant's convictions be upheld. Thank you.
I guess just briefly, again, going back to this res gestae where attempt must mean something different in felony murder land. My colleague has said it's a factual impossibility for there to be an attempt within an attempt. And I think if you include the attempt of the res gestae of felony murder, we're now 3 layers deep into attempt here. We have an attempt to transfer and an attempted distribution of methamphetamine that the attempt occurred during the res gesta of a murder. So if you get 2 layers of attempt and that's factually impossible, I don't know how we get to 3 layers of attempt, and that's fine. I think it's very clear here that Patricio did try to transfer drugs.
If we just look at the raw elements in the statute, and I guess leave logic aside, why couldn't a person be guilty of both attempted distribution and distribution under the elements?
Right, because I think an attempted distribution is a completed distribution.
And that's the logic part of it, and I get that, but I want us to focus, at least for the purposes of my question,
Okay.
just on the elements, because I think there's the argument is has at least some resonance that you're making, that the elements of the completed crime incorporate an intent. But if we look at the elements of, attempt, that also is met, right? Aren't both crimes essentially met under the facts?
Well, an attempt requires the failure to complete the crime. And because my argument is that we've completed the crime, I don't know how you can fail to complete the crime to support an attempt.
So failure is, your argument would be that failure is effectively an element of attempt.
Yes, you have to fail to complete the underlying crime. Otherwise, you've completed the crime.
Okay.
You haven't attempted it.
So your argument is that even within the elements, the law precludes that as a possibility.
Yeah, that
Okay.
would be correct, Your Honor. And so again, Patricio's argument here is there's insufficient evidence of both means to support felony murder here. There's insufficient evidence of an attempted distribution of methamphetamine. And as the jury found, and as I think the record is clear here, there was no attempted aggravated robbery. And without sufficient evidence of either of those means, Patricio's felony murder conviction must be vacated and he cannot be retried. And so that would be our request today, is that you vacate his convictions for felony murder and attempted distribution of methamphetamine. And in that case, you won't need to remand for resentencing. So I appreciate the court's time unless you all have any more questions. Right. Thank you.
Thank you. We thank both counsel for your arguments today. The court is now in recess until 9 a.m. tomorrow.